All right. Good evening. Good afternoon. My name is Amy Bach, and I am so happy to be bringing you information this afternoon. I'm glad that you were able to dial in, and those of you who know people who were not able to log on at this time, just know that we are recording tonight's session in both English and Spanish. And we will make the recording available on our website and via our YouTube channel. And we encourage you to let friends and neighbors know about that. Annabella, do you want to make a brief announcement to our audience? Gracias. Okay, so this afternoon's presentation is for anyone who has had their home damaged or destroyed in one of the many 2020 California wildfires. And we will be talking specifically about the rules that apply to insurance claims and your legal rights in the state of California. And it's good to, and here's a bit more information about the Spanish option. You can see there at the lower part of your, or wherever your Zoom control panel is, there should be a button that looks like a globe there, and then you go to that and you pick the language. So if you're listening in English, I don't think you have to do anything. But if you want to listen in Spanish, you go there and you click Spanish. A little bit of fine print. This workshop is intended to be general guidance only, not legal advice. We don't endorse or warrant any of the sponsors that you'll find in our Find Help directory or on our website, but they are volunteers, or they are, in the case of our Find Help sponsors, they are businesses that support what we do. And so I very much encourage you, if you do need specific legal advice on an individual problem, first place I would recommend is you go to our Find Help directory for the state of California, and you can see that we have quite a few experienced lawyers that call themselves policyholder lawyers, meaning they help people who are the buyer, the consumer, the user of insurance. They do not work for insurance companies. I'm paid UP staff. We don't have any outside speakers at today's workshop. Sometimes we do. About United Policyholders, we've been helping disaster survivors and advocating for insurance consumers since 1991. We are not for profit, just like the Red Cross or the Sierra Club. And we say we're not for sale. We don't take money from insurance companies, so we can give you the straight scoop about insurance and keep an independent voice. We're funded by donations and grants. We are trusted and respected across the country. We run 3 programs. We have a preparedness program where we teach people how to take steps to avoid losses, to fortify your home, and also how to buy insurance that is going to be there for you when you need it. And then we run our Roadmap to Recovery program, and that is that's the program through which I'm bringing you information today. That program focuses on helping people who have had a catastrophic loss get from point A to point B. Point A being you're standing in the wreckage of your home, or you're trying to, you've got a damaged home and you want to get back as close as possible to where you were before that loss. The Roadmap to Recovery is a series of offerings, workshops like the one we're giving tonight, our special dedicated library for 2020 wildfire survivors, the legal clinics that we offer. We have our first one next week. And then all the information that you'll find on our website, sample letters, tools, our sample inventory, all of that is focused on helping you on your journey to recovering from a catastrophic loss. And then we also do advocacy work in the legislature, in the courts, standing up for your rights as an insurance consumer. So
Amy, can I cut in for just one second? We had a quick question that I think would be well addressed here.
Okay.
Will this webinar be specific to California? We have some Colorado folks and potentially some others as well.
Oh, okay. So yes, this is definitely specific to California, but for those of you who are in Colorado, I would encourage you to stay on for a couple reasons. For one thing, we are launching our Roadmap to Recovery program in Colorado, and a lot of the information I'm going to go over here is relevant. Now, not all the laws and protections that we have in California are available to you in Colorado, but some of them are. The insurance company's basic obligations and that sort of thing. Although some of the specific time deadline extensions that we have in California, you don't have in Colorado. We will be doing a roadmap orientation in Colorado in the next couple of weeks. So it's really up to you. I mean, I would, stay on as long as you can. And if you just feel like, I will be specific when it's something that only California has. So thank you for that question. So a few reminders. And by the way, we also do have a special library for Colorado for the Roadmap to Recovery there. And we have volunteers, we have lawyer volunteers in Colorado, we have some public adjuster volunteers, we have public official partners in the state of Colorado, just like we have in California. But when it comes to the dynamic of insurance claim rules and laws, there are a lot of sort of basics that are worth understanding. One is there's no one size fits all path for recovery, and we really encourage on understanding that it's a process. Recovery is a process, and it's overwhelming. And you cannot deal with everything at once. And so we really encourage you to understand that it's one step at a time. That's how you get through anything that's overwhelming. You break it into bite-sized pieces, take a bite, chew it up, take another bite, right? So take your time. Rumors are always rampant after disasters. And when I say self-protect, what I mean is, take everything, take things with a grain of salt, and people can tell you things. Oh, you shouldn't do this, or you should do this, and it really, a lot of the time, you want to just sort of process it and let the information come in, and take your time, because what's the right path for you is the right path for you, and what might be the right path for your neighbor might be right for them. So, for example, if your neighbor is one of these people who says, I'm going to be the first one rebuilt in my neighborhood, that can come at a price. And so that doesn't have to be you. If that is you, that's fine. We're here to help with that as well. But just know that don't get too blown off course when you hear rumors and people telling you things that you must do. There's no harm in asking for exceptions and extensions, and that is universal when it comes to insurance. Okay. The adjusters that get assigned to catastrophic loss claims have a wide range of skills and experience. Some of them were flipping burgers, a month before they got hired by the insurance company. Some of them have been working in the insurance business for a long time, and it's kind of the luck of the draw who you get. And even though your adjuster may try to make it seem like everything is very black and white and cut and dried in the insurance policy and the process, that really is not entirely true. An insurance policy is a contract, and it's a legal contract, which is why I'm here teaching today's workshop, and I'm a lawyer. But it is there's more flexibility in the process than an adjuster might let you think. So, for example, additional living expense, temporary living, the money that you get for your temporary rent for wherever it is that you're living, and expenses that you're incurring because you have lost the use of your home, right? Loss of use, temporary, additional, all means the same thing, right? It's the expenses you're incurring because you lost the use of your home. Well, this legal contract insurance policy makes it seem like you only have one choice. You have to get money from the insurance company to cover your rent, and you have to pay rent. That is not always the case. Many people have been able to negotiate by asking for an exception and say, I want to be on my property during the rebuild. So I want to use my ALE, my additional living expense, temporary rent, loss of use, again, same bucket of benefits, to buy a tiny house or buy a fifth wheel or buy a yurt or a trailer. And that's what I want to use my temporary rent for. There is no harm in asking for that, particularly if it's going to potentially save the insurance company money down the road. So if that's going to be, your 2 years worth of rent, that you can try to negotiate that. No harm in asking. They can say no, and you can try to negotiate back, but no harm in asking. And the same thing goes with deadline extensions. If an adjuster says, I need your inventory, and here's where it says in the policy, 60 days, and you say, I can't get it to you in 60 days, you ask for an extension. It happens all the time. And we have sample letters to help you get extensions, because obviously you're a human being, the adjuster is a human being, and a certain amount of common sense applies to the situation that you're in. Very important point here on this slide. Give your insurance company a chance to do the right thing on your claim, but don't be a pushover. And the reason we say that is that most people have an idea about what insurance is all about based on ads that they've seen. So, Flo with the magic wand, or, the film, shows the fire and then it rewinds and it goes back. And most ads give you this idea that the insurance company is going to take care of you. They're your good neighbor. They know they're the professionals. They're going to handle it. And so a lot of people will approach their insurance claim with a passive mindset. Like, okay, I guess the insurance company knows everything. I don't know anything. So I'm just going to let them drive this thing. And our advice after 30 years of helping people recover from wildfires is you're much better off if you speak up. And how do you do that? Strong as possible, that's the S. Paperwork organized, that's the P. E for empowered. A for assertive but polite. K for keeping a claim diary. I for insurance educated. You're here now getting insurance educated. N for networking with others. That's again something you're doing. You're networking with others by being part of today's workshop and any other forums that are available to you. G, getting professional help when needed. U, unwilling to be shortchanged. That's an important one. And then P, proactive. So when we say give your insurance company a chance to do the right thing, but don't be a pushover, we're saying you don't have to be combative. You don't have to come into this thing with your fists up, ready to do battle, right? But you do need to understand that when it comes to a catastrophic loss claim where a lot of money is at stake, it's nothing like what you see on TV. You're not dealing with your good friend. You're not dealing with your good neighbor. You're dealing with a for-profit company that has a incentive that's not the same as yours, right? You want to max out the benefits, and they want to pay basically as little as they can get away with paying. And it's not that they're evil. It's just that they are a business. They are a for-profit business. So even though they sell you this idea that they're going to take care of everything, our message is it's your assets, it's your net worth, your financial health, your quality of life. You have the biggest stake in making sure that you get every dime that's coming to you. And so you need to be savvy and don't be a pushover. That's the point I wanted to get across. So what are your basic insurance rights and duties? And this is going to apply in any state in the country. Your insurer must thoroughly and fairly investigate, adjust, which means measure, tally up, and pay your claim in a timely manner, okay? That's their basic obligation, right? So every court in the entire country would say that. right? That is the insurance company's duty, because they took your money and said that they would be there if you needed them, and they have it at the very basic. They have an obligation to thoroughly and fairly investigate, and then adjust or pay timely, right? Does that principle get violated every day, all day? Yes. Part of why United Policyholders exists is to help you assert your rights, because you have rights, but you have to assert them very often. That's where the proactive part comes in. And we're here to explain to you what those rights are. Okay. You also, your insurance company has a duty to cooperate with you, meaning they have to give you the forms that you need, and they have to explain the processes to you. They cannot leave you in the dark. But you also have a duty of cooperation to give them information, to answer their questions in a timely way. So cooperation is a two-way street. And I say that it's important because one of the reasons we talk a lot about a paper trail and keeping that journal is that it is important that there be a record if there ever become a problem with your claim. It's important that there be a record, a history of what has happened that shows that you've got you've done your part, you've cooperated, you've made your property available for them to inspect. You have communicated with them. You have answered their questions, reasonable questions. You have given them documents. And it's important to do that, even though sometimes, and it should not be an adversarial process, but for some people and more people than it should be, can be adversarial, especially when there's a lot of money at stake. So people say, well, I feel like my insurance company doesn't trust me, or they are it seems like they're accusing me of trying to cheat them, right? And that is that's just sort of the nature of the dynamic that I was explaining, that you just have different objectives. They want to get in and get out. You want to max out, right? So that's why I really emphasize having the right frame of mind when you're approaching your insurance claim, because that's the best way to have a reasonably good experience is to not be passive and to really understand as much as possible, not just your rights, but your loss. What did you lose and what's the value of it? Because if you sit back and let the adjuster tell you what they owe you, a lot of the time, you're not going to max out. That's just the reality. Okay, so but like I said, we're not saying you should come in with your guns blazing and fists up, because again, adjusters are people. So you get on their bad side, they may make life more difficult for you than it already is, and you don't want that. So you really want to be pretty savvy and pretty professional about the whole thing, as professional as you can. And I know that that's easy for me to say, but it can be very hard, when you have had such a serious loss and you're vulnerable and you feel like if the insurance company isn't behaving well, it's easy to take it personally. But my suggestion is you just really try not to. Just try to understand that's the dynamic, and you're going to speak up. You're going to speak our language. So we say, trust but verify that your losses are being fairly valued and that all available benefits are being explained accurately and paid timely. So give them the benefit of the doubt, but again, be educated, which is why you're here, right? So that, and also verify. So that's where you get second opinions on things, on the value, the replacement value of your house, the replacement value of your possessions. Because you did pay money for both coverage for your loss and good claim service. So you have that right. Okay, so you have the right to coverage and you have the right to good claim service. Doesn't always get delivered. Sometimes it does. We certainly hope you get every dime, and we hope things go smoothly for you. And I'm not here to tell you that you're in for a fight and all that. You may get a good adjuster. your insurer may be doing great. I hope that's the case, but it's good to have your eyes open. So obviously you're going to start with trying to understand how much money is available in your policy, because the contract, the insurance policy, states your rights as to how much money is available. We did a great webinar a couple weeks ago on how to read your policy and do the math to figure out what's the maximum amount of benefits available to you in that policy. And that is a really good starting place. So, and there's a law called contra preferendum that you don't need to know that Latin, but it basically means the insurance company wrote the policy, right? They drafted it. So if there's something in the policy that's ambiguous, that's not clear, and you have one reading of it, let's take this, for example. Here's a policy provision that's that might be in your policy if you have a Safeco policy, that if there's a declared disaster and that impacts your home, you get an extended amount of benefits, right? So if you had language like this in your policy, and you took one reading of it and you said, well, okay, looks like I get this twice, I get double my coverage here for my extended coverage. If your reading is reasonable, because the insurance company wrote the policy, that contra preferendum says it'll get interpreted against them and in your favor, as long as you have a reasonable reading. If your reading is not reasonable, that principle is not going to help you. Anyway, there's the link to that webinar on how to read and understand your policy. And again, that's free. You can watch it at your convenience. What are the sources of your legal rights? There are 4 of them in California, and there are probably 4 of them in Colorado as well. Not probably, there definitely are. So that will be the insurance code in your state. That will be the statutes that the legislature has passed, okay? Official opinions, bulletins, or directives of the state agency that regulates insurance companies. In California, it's called CDI. In Colorado, it's called DORA, the Division of Regulatory Affairs. They have an insurance section of that. The third source of your legal rights will be regulations. And those are also laws. In California, we have a lot. We have in the California Insurance Code, we have the Unfair Claim Practices Act that says all the things an insurance company is not allowed to do. And there's all kinds of things in the code. We also have the Code of Regulations, a whole nother laundry list of things that insurance companies are not allowed to do and or must do. And then the fourth source, and you have that in Colorado too, I'm sure, are case law, decisional law. So those are the laws that judges write when they write an opinion in a case where there's been a dispute between an insurance company and their customer, and it got resolved in court and the judge has written an opinion. That's also a source of your legal rights. Okay, here are 2 very important places for you to go whenever you need a question answered in California. Our website, our library for the 2020 California wildfires, and then the Department of Insurance in California. Same thing in Colorado. You have our library for the 2020 Colorado wildfires, and you have DORA's website. Your insurance commissioner in Colorado is Michael Conway. Ours is Ricardo Lara. Both of them are progressive Democrats, very consumer oriented, and they can be really helpful. Okay, your right to information. You have the right to a complete and current copy of your policy. You have the right to get that within 30 days after you request it in California. You have the right to know how your insurance company calculated depreciation. We're going to talk about that a little later, and how they came up with your settlement offer. And that's an important one, because a lot of times an insurance company will give you they'll make an offer. They will make a settlement offer, and to you, they'll say, this is how much we owe you. And you have no idea how they came up with that. So you have the right to get a breakdown. from your insurance company on how they calculated that offer. And that is the provision of law that gives you that right. Okay. I'm pretty sure that you have this right in Colorado, but I'm not 100%. So I just want to say for sure in California, and I know this because I helped write this law, you have the right, even without filing a lawsuit, you don't have to do that. You don't have to hire a lawyer and have that lawyer officially request documents. You can do it on your own in California. You can write to your insurance company and request your claim file. You can request all their measurements, their drawings, their scopes of loss, anything that they have gotten on your behalf. And you have the right to get that as long as it's not a suspected fraudulent claim or there's some attorney-client privilege that they might say. But for all this basic stuff, you have the right to get that. And we have a sample letter on our website for you to request that. So when would you want to do that? You would want to do that if, for example, your insurance adjuster makes you a settlement offer for a certain amount, and they tell you how they broke it down, and it doesn't seem like it's enough to you, and you've trusted but verified, you've followed UP's advice, and you've gotten an estimate from a real life builder, and that real life builder is telling you that the replacement cost of your home is more than what the insurer is offering, but you want to see how the insurance company really, did they talk to a contractor to get that estimate or what? You can ask them for your claim file, and you can see even more than just the breakdown. You can see, did they get an inspection report, or did they dig up plans on your home, or what did they do to come up with their estimate? Okay, so that's important. You have the right to an orderly claim process. So if you write a letter to your insurance company or an email, they have to respond within 15 days or tell you why they can't or ask for an extension, which they do all the time. Okay. They must disclose all benefits, coverage, time limits, and all that. They can't hide the ball. Again, sometimes they do, but they are not legally supposed to. Okay. So some of these laws that I'm talking about and your legal rights, they're out there, but often you have to take steps to make sure that they are being enforced. And that can be, you can take those steps on your own, or you can go to the Department of Insurance and get them to enforce the law, or you can go to a private lawyer and get them to help you enforce the law. You are entitled to a status report. Hopefully you'll only have a couple of adjusters, but it's pretty common that after disasters that the first adjuster that was assigned will rotate out, and then somebody else will get assigned, and then sometimes that one will rotate out. It's very frustrating, but it is also very common. And for that reason, our organization helped get a law through that gives you the right to get a written status report on your claim if the adjusters if you've gotten more than 3 adjusters in a 6-month period. And here's where you find that right in the California Insurance Code. If you get a third or subsequent adjuster within a 6-month period, they have to give you a written status report. Okay. And then for all of you, because most of probably everyone on this webinar, everyone who's who logged in here and paying attention, you probably were affected by a state of emergency, so you don't need to wait 6 months. If you get a third, if you've already had 3 adjusters, you already are entitled to get that written status report, and the insurer has to give you a primary point of contact, so that you can be in touch with them. And I'd say of all the years that I have been helping people out after disasters, and our organization has been active, probably one of the most common complaints I've heard from people is that they can't reach a human being at the insurance company. and that is unacceptable, and you should document that in your journal and confirm it in written material, written emails or letters to the insurance company. This will confirm that I have been trying to get a human being and I can't. That's not legal, and it's not acceptable, but it is common. Okay, choosing who will repair the property. For those of you who have a total loss, or those of you who are looking to rebuild, it's your choice. They cannot force you to hire any particular company unless you ask them to do that for you. And in California, you have a right to full payment of policy benefits, and that includes at least 36 months from to collect full replacement cost benefits. And I'm going to explain that. I already said I was going to explain it, so this is the second time, so I'll explain it right now. There are two ways that an insurance company values your loss: the actual cash value, which is also known as the Craigslist value or the depreciated value, as was used condition, and then the replacement value, which is how much is it going to cost you to replace that asset. And since you can't buy used for used, you have to buy new. That's why most policies today will give you actual cash value as soon as you've reached an agreement with the insurer over that used Craigslist value, what somebody a willing buyer would have paid a willing seller the day before the loss. And then when you establish the replacement value, to put it back, restore it, buy a new couch, put a new house back, they owe you that difference in most policies. The difference between ACV and RCV is what you will be owed. And what we're talking about in this slide is how long do you have to claim that difference, right? How many months or years do you have to replace that couch, to rebuild that house, and collect your replacement costs, the full amount, right? It used to be a much shorter timeline in the way insurance companies designed the rules, and it wasn't enough time for disaster survivors. So we lobbied hard, and we got the law changed twice. At first, it went to 24. Now it is, you have 3 years in California from the first ACV payment, that first actual cash value payment, until to collect that difference, right? And for a lot of people, you need that time because, for example, it takes a lot. Most people, it takes well more than a year to replace a destroyed dwelling. So you're not going to go buying furniture until you know how big your house is going to be, or what colors the walls are going to be, or what have you, right? So most people need at least 24 months in order to give the insurance company the receipts and the proof, that they spent the money in order to, to be made whole. Then you also, in Colorado, I don't think it's the 36 months, so I don't want to speak to that on this webinar, but in California, you've got that. You also have the right to fair depreciation based on age and condition. Now, this is important. Why does this matter? Why does the ACV payment matter when so many things are covered for their replacement value and you're going to get that anyway? Well, first of all, a lot of people actually never do go back and replace a lot of things. So the ACV payment actually really does matter in a lot of situations. And there are some things that only get paid on an ACV basis anyway. But also it's important that you get that you get a fair payment for your ACV, because very often that's the cash that you need to keep on keeping on, right? To start to make your decisions and start to replace your possessions. And why do we sort of harp on this? Well, it's because insurance adjusters, just like many other employees in a corporate setting, they are stretched pretty thin. A lot of insurance adjusters are handling more claims than they really should be able to, than they should have. So they're just trying to do shortcuts a lot of the time. And so what that means is they will sometimes try to depreciate all your stuff across the board. Let's say 15% depreciation on everything. That's not legal. And also in California, the condition matters. So it's not just the age, it's also the condition, right? So it's important that you know that you have the right to have your property be fairly depreciated, not overly, okay? You also have the right in California by statute to at least 2 years of temporary additional loss of use expenses. Again, we talked about this. You have at least 24 months plus another 12 months if you can establish that you need it, for a maximum of 36 months. So you can continue to collect your temporary rent for up to 36 months as long as you can show that you are cooperating and trying to move forward, and that if circumstances that are beyond your control mean that you cannot replace things, or you cannot move back in to a replacement home before then, you can keep collecting those temporary rent benefits, additional living expense, loss of use. But again, you're going to have to document that in writing. It's not automatic, right? The 24 months is automatic, but that additional 12 is not. You have to really, sometimes you have to fight for it. The law gives you more time, but it doesn't give you more money. So you still are gonna, you're still gonna have to stretch out the amount of your ALE, additional living expense, temporary loss of use benefits. You're still gonna have to stretch them out. Whatever the max is in the policy, you have to stretch it out for whatever time you're gonna need it. Now, some policies don't have a dollar amount. State Farm, for example, is just as incurred. But again, they're not going to just give you a blank check, right? You're going to have to show them what expenses you're incurring and that they are reasonable, all right? You do have the right in California to replace your home by buying, not rebuilding, which is a really important right. You have that right in case law in Colorado, but it's not in statute, so it's a lot harder to negotiate that if you don't want to do the rebuild and you want to buy. But in California, we got you on that one. We got some work to do in other states on that, but on that one, that's a very clear now legal right. The legislature has 3 times now told the insurance companies, no, we really mean it. You have to pay people their full replacement value, even if they don't rebuild, right? As long as they replace it up to that amount. Okay, so just back to this RC versus ACV. Now you are all familiar with these terms: replacement cost, cost to replace new; ACV, cost to replace an instant before the loss. Your policy is going to have language in it about which items are paid on an ACV basis and which items are paid on a replacement value basis. Obviously, for things like antiques where you cannot replace them, one-of-a-kind things, they're going to be valued at their ACV, but they shouldn't be depreciated. Antiques shouldn't be depreciated because they actually gain value over time. Same thing with collections, silver, jewelry, but you're going to have to provide proof of their value. Okay, so this is another code section that you may need if your insurer, if you feel that your insurer is holding back benefits that you are entitled to. Fair depreciation. Most policies allow the insurance company to depreciate to reflect the condition property was in at the time of loss. But as I said, they have to consider both age and condition. And we have great information on our website about this topic. You can put into the search box at uphelp.org the word depreciation, and you will get to all kinds of short and longer tips and tools for negotiating and presenting a good case for fair depreciation. And it does matter because for, again, in a lot of situations, that may be all you end up collecting for various reasons, right? There isn't an official depreciation schedule, which is frustrating because some insurers will apply more depreciation to furniture than another one. And that's why we have a lot of materials on our website to help you really get a fair amount. So here's that the definition in the code of actual cash value, and it applies to both total and partial losses. Depreciation gets applied to both your house and your stuff. It doesn't get applied to your ALE, your temporary rent, but it does get applied to your stuff and your contents and your dwelling. This is another helpful graphic so that you can see what we're talking about here. Okay, the replacement cost to put your home back together with a new building material versus actual cash value, the value before the loss, and then a deduction for due to wear and tear. Okay. So the time limit, we talked about this. You get 36 months in California to collect your full replacement. That benefits everything that they owe you. That's gives you 3 years not to leave money on the table. We talked about this, just restating. In California, you have up to 36 months for your additional living expenses. And as I mentioned, 24 is a gimme. 12 months is a maybe, as long as you show that you've been doing your best and it's not your fault that you haven't been able to move back in. We have a law in California that was very hard fought. I know you don't have this in Colorado. And here's the code section in California Insurance Code 10103.7. If it turns out that you're underinsured, and when we hit you up to do one of our roadmap to recovery surveys, I'm here asking you, please fill it out. Our surveys are very, very important. It's a very important way we help you is we do these surveys. We generally do them either 6 months and then we do a year and 2 years. So you can tell us what's going on. When we do surveys, and we've been doing them for many years, people tell us that they're underinsured. In fact, 2/3 of the people typically that lose their homes in a disaster find that their dwelling, their home, was not fully insured to the real cost of putting it back. So chances are pretty good that you're underinsured, especially since you've tuned into this webinar. So one of the strategies for dealing with the fact that you're underinsured is to grab coverage for other structures that you may not have or need, but that was in your policy anyway. So garages, outbuildings, retaining walls. So this statute allows you to grab, to combine some those limits so that you have buckets of coverage. If you go back and you look at that webinar where we taught people how to read your policy and figure out how much you've got, you've got buckets, right? You got your dwelling, you got your contents, you got your other structures and loss of use, debris removal, trees, shrubs, landscaping. This law allows you to combine some of those limits if your dwelling is underinsured, and that can be very helpful if you don't have enough to put your house back. Okay, what are your legal rights with pricing disputes, which are super common? Okay, these days insurance adjusters are relying way too heavily on a computer program called Xactimate, put out by a company called, well, the software is Xactimate, and it's a computer program for construction cost estimating. And it's what we say about computer programs for estimating is, you hear the expression garbage in, garbage out. All that really means in this context is that the estimate is only going to be as accurate as the information in that software and the expertise of the person doing data entry are. So if the person who puts the data entry in, puts the information about your house in, the adjuster puts it in, if they don't do it right, if they miss things like a whole room or, a chimney or something like that, it's going to come out wrong, right? Similarly, if the software is using pricing that's not accurate to your region, it's going to come out wrong, right? So Xactimate, it's not that it's a flawed product so much as you have to know how to use it. And most importantly, computers don't build houses, builders build houses. So insurance companies are they're using the software, and that's going to be the basis for a lot of your settlement offers, is going to be this fancy looking 1 inch thick or more stack of papers with 1 million lines, and it looks like, oh, it must be accurate because it's 1 inch thick. But the reality is that a builder in real life in your area is generally going to give you a much more accurate estimate, because they're going to give you an estimate for doing the work, whereas the computer has maybe using pricing for a tract home in Sacramento, which is probably a lot cheaper than what it will cost to rebuild a custom home in Sonoma or Napa or in the Boulder Creek or wherever you may be, right? Same goes for Colorado. It's a lot more expensive to rebuild a home that's on a slope than it is to rebuild a home that's on a flat. It's a lot more expensive to build a home that's a freestanding home than it is to build one that's right up against, another one, or, that's, anyway. So the point is that you have the right to a fair payout, right? For what it would cost to put back your house, not a tract house in Sacramento, but your house, right? So if after you get that estimate from the insurance company, and you get your second opinion and there's a difference, you have rights to get paid on your estimate as long as it's reasonable. You don't have to take what they offer. The challenge, and this is a statute that says that, right? There's a lot of other rules that say that. There's this thing called the covenant of good faith and fair dealing that I'm going to touch on briefly in a few minutes. But you have the right, if there's a gap and they're saying in the Xactimate, or if the adjuster's got some contractor that works with them all the time and they're saying, oh, this project can be done for $300,000, and you've got an estimate or two, or from a builder with subcontractor bids. And if if theirs is X and yours is Y, you have the legal right to be paid Y, as long as you can establish that Y is reasonable, that it's not inflated. Okay. And there are different ways for resolving those disputes, but you are not legally obligated to just take what the insurance company offers. That's the main thing I want you to understand. Right. Okay. So we talked about this briefly, that in California,
Amy, can I chime in here right before
yes, please do. I'm sure everyone would love to hear another voice.
So this is a question that relates to underinsurance, and I know that you're going to talk about that a little bit later, but it also ties into something you mentioned before. So I want to hit it now.
Okay.
If you are underinsured, do you have the right to use part of your ALE bucket to replace your dwelling? And I know you were talking about other options for ALE, so I was wondering if you could circle back and tie that question in.
That fits in that everything is negotiable to a degree bucket. So that the code doesn't expressly allow you to use ALE, especially because ALE is typically paid on an as incurred basis, meaning they're going to say, well, we don't know how long it's going to take you to rebuild. Maybe it's not going to take you 3 years, so we don't owe you 36 months. So the question is going to be, how much ALE can you negotiate, for them to advance to you? And so it's a negotiation is the answer, and they may say no, and technically you don't have the legal right to collect your ALE in advance. That's just, you just don't have that right. But you certainly can ask. And when I hit on the voluntary claim reforms in California, they do give you the right to an advance of 4 months of ALE. So again, this is something that you negotiate. You try to negotiate it with your adjuster. Okay, so buy or rebuild, you have that right in California. Here's the code section that gives you the right. And it's a great way to get out of harm's way. For example, if you're living in an area that's very vulnerable to wildfire, and you're thinking maybe you just don't want to stay in that region, the right to buy a replacement home can be very useful. But it's still relatively new. I mean, it's been on the books for over 10 years, but insurers are still having a hard time getting with it. And so you may have to use our resources to push back on getting every dime that would have been available if you rebuilt, and get that money agreed to, and then use that money to buy a replacement home. Okay. Small note, once you buy the replacement home, that cuts off your ALE benefits. So that's what I was talking about there with the negotiation. All right. So if you are thinking, so if you are thinking about not rebuilding the exact same house, you have 4 options when you've lost your home. You can rebuild the house as it was, same size, same footprint, same number of bedrooms, etc. You can rebuild a different house. You can buy elsewhere, or you can rebuild elsewhere. Those are your options. But to max out your insurance, right, you must establish the top cost to rebuild the house as it was. That's what the insurance company owes you, subject to the details in your policy, but that's the measure, right? So a lot of people go off track here because hardly anyone wants to put back the exact same house that they had, right? Most people want to downsize, or they want to add something, right? But the fastest way to get it crosshairs with your insurance company is for them to think that you're trying to profit from your loss. So if they think that you're trying to build a bigger house on their dime, that's going to be hard. That's going to make things hard for you. So we really encourage you to focus on figuring out what it would cost to put that house back the way it was before you really get too far down the road with other decisions. All right.
Hey, Amy, I'm going to chime in again. This
Sure,
is on the same topic, and it was a very timely question at the beginning of this section. Okay. So if you know you are not going to rebuild, do you still need to get an architect and builder's estimate for rebuilding to get the full amount of your underinsured home?
So I would say architect, not necessarily. Builder, yes, right? Because the problem with, and I'm going to go back for a minute, the problem with this trust but verify, and I'm talking to you about how the computer spits out the estimate, and the adjuster makes you an offer to settle on that, and it doesn't, and it doesn't look anything really like what a real life local builder would tell you. Is a real life local builder is not going to give you a detailed enough estimate unless detailed enough to satisfy the insurance company and their requirements, if they know they're not going to get hired to do that project, right? They'll give you a super detailed estimate for the house you want to build, that they want to get hired to build, but they're not going to do that for free in most cases if they know they're not going to do that project. So in order to reach that, sometimes you're going to have to pay somebody to give you that. So we have a couple of we have about 4 outfits in our Find Help directory that you can pay them to do an estimate for you that's going to be detailed enough so that to be the basis of an agreement, but isn't so detailed with architectural drawings that somebody could actually build that house, right? So you're trying to kind of thread that needle, and it can be tricky because it's in outside of disasters, you're not going to find somebody that's going to give you that's going to do that kind of an estimate for you unless it's somebody that you're thinking about hiring. So for land value deduction, this is for those of you who don't want to rebuild and want to buy. If the insurance company says, well, we're going to, let's say, for example, you have let's use the, we've got some good slides coming up that illustrate this, but the bottom line is that your insurance company may say, we're going to deduct an amount for the land under the house that you want to buy. We don't think that they have the legal right to do that. And the legislature, because they in some insurers were doing it, not all, but some were, we had to go back to the legislature and say, you need to clarify this. And they said, no, we mean it, insurance companies, you cannot deduct the value of the land, because what they owe you is what it would have cost to put back that old house, right? When you purchased your house, you bought the structure and the land that it sat on, right? The home insurance doesn't cover the land. They always tell you that, just the structure, right? So let's say that you insured that home for $400,000. That was determined to be the replacement value of that house. How much it would cost to put that house back, right? $400,000. So if you decide that you want to buy, then you look for a house that costs $400,000, right? If you don't want to spend money out of pocket, you just want your insurance benefits to get transferred over. So if the insurance company tries to deduct an amount from that $400,000, you're not going to max out, right? That's why we say, don't let them make a land value deduction, right? Because if they do, you're going to get left. You're going to end up with a house that's less valuable than the one you had, right? Because like for like would be $400,000. It doesn't matter that new house is sitting on land. So that is the argument we advocate that you make, right? Because otherwise you get shorted the value of that land. You get a lesser house, right? If they deduct the land. But again, insurance companies have been having a hard time swallowing this because they like the old way, where you end up leaving money on the table, which we don't want you to leave money on the table. Okay, your right to be treated fairly. Remember I mentioned earlier this thing called the covenant of good faith and fair dealing. So in California, it's written right into the law. Your insurance company has a duty to act in good faith and treat you right? Colorado has the same thing, but it's in the case law and in the Colorado rules. All right, so what is bad faith? And you hear this bandied around, and I'm sure a lot of you have already, maybe you thought about hiring a lawyer, or maybe a lawyer approached you, or maybe you've heard this phrase, bad faith. And really all it means is unreasonable conduct. That's what it means, okay? And because insurance is different from a normal contract, right? In a normal contract, you buy something, the seller gives you something tangible, right? You buy a refrigerator, you get a refrigerator, right? When you buy insurance, it's not tangible, right? You can't see it. It's peace of mind. It's financial protection. So it's the law treats insurance different. The law holds insurance companies to a higher standard than they would hold a refrigerator seller to, for example, because all the refrigerator seller said is, we're going to give you a refrigerator, right? The insurance company said, we're going to take care of you if something bad happens, right? So because of that, you have rights to be treated fairly that are special because of this being an insurance transaction, right? And that means that if the insurance company is not treating you reasonably, if they're not acting in good faith, and you hire a lawyer and you sue them, you have rights to collect money from them, more money than you'd be able to collect from a refrigerator seller that sold you a bad refrigerator, because the law says that the insurance company took your money and made you a promise, and they've got to deliver on that promise. Okay. And that's where that coverage plus good claim service comes in, right? So they have to notify, they can't just cut off your rights. They have to tell you if there's a deadline in the policy. They have to tell you when the statute of limitations is going to run. And you guys don't have to worry about that at all right now. I mean, if you're just in the beginning of your claim, you've got plenty of time. You don't need to think about a lawsuit. You need to be thinking about speaking up, keeping your diary, and tallying up your losses, and making sure that you understand how much insurance you have available. Okay, they can't lowball you. That's right in the code. Lowball. They can't say, you know, here's 300,000 when a builder is telling you it's 400,000. All right.
Hey, let me
Sure. Jump in.
1 second. This is an appropriate question here. Are legal fees associated with disputing a claim typically covered as rebuild costs?
So the question is, if you have to sue an insurance company to get benefits that they were unreasonably withholding from you, can your lawyer fees, can you make them pay your lawyer's fees? And the answer is yes. If you establish that you had to hire a lawyer to collect benefits that you were owed under that contract, and of course you shouldn't have had to go to all that trouble and incur that expense, but if you show that you did have to, that they were not paying and you had no choice, then yes, you can get your attorney's fees. But, and this is a big but, if you run to a lawyer a month after you filed your claim just because you don't want to deal, that you may not get those fees paid, because the insurance company will say, well, they didn't even give us a chance to do the right thing. So it's not automatic, right? So don't go out and, hire a lawyer tomorrow and think that their fee is going to get reimbursed. It doesn't work like that. Okay. They can't discriminate against you. So, that's one of the reasons that United Policyholders encourages people to get together in groups, because by insurance company. Because if you find out that if you're insured with Farmers and Farmers is telling you that they won't give you an advance on your contents, or they're not abiding by the voluntary claims reforms, and they won't give you an advance on your temporary rent, and you find out that your neighbor who's also insured with Farmers is getting an advance and you're not, that's discrimination. And that can, if you find out about that and you speak up about it, then you can make that right, because they're not allowed to discriminate. They have to treat their insureds the same. The voluntary claim reforms is a deal that the insurance commissioner negotiated some years ago, and behind closed doors. So it's not law, and that's why we call it voluntary. And it did become law, but it doesn't take effect until January. So for you guys, it's still the insurance company's option whether they're going to give you 25% of your contents benefits, 4 months of temporary rent in advance without requiring you to spend the money, give them the receipts and all that. Okay. There are rules about for the insurance company disclosing benefits. We talked about discrimination, the voluntary reforms. I talked about that, the 4 months. These are maybes, right? But you should always ask, right? Because most insurers are abiding by this, right? 4 months advance on your temporary rent, 25% of your contents limits without having to do an inventory. They're also among those voluntary reforms is to give you some flexibility with how you put in that loss inventory, right? They should let you itemize in bulk. So instead of having to list every single title of a book or every single thing that was in your medicine cabinet, they should let you bulk list it. So say contents of medicine cabinet, X dollars, right? The debris removal, they absolutely should agree that if you participate in the coordinated debris removal program that your local government is organizing, if they are organizing it, your insurer should work with you on that. These are 2 bulletins that to apply your coverage to that, so you don't have to go out of pocket for debris removal. These are 2 bulletins that the California department put out that can be helpful to you. One of them is giving you a grace period for paying your premiums. Another one is to encourage them to advance funds to you to without nitpicking you to death on itemization. So what are some of the common hot spots? We've been talking about them. The adjuster thinks that you're trying to pad. The adjuster thinks you're trying to build bigger and better. Scope and valuation disputes, whose numbers are right. Depreciation, the things that I've been talking about. Very common, you get an adjuster from out of state. Gosh, in Iowa, they don't protect consumers the way we do in California. What can I say? California has very strong consumer protections. If your adjuster is not aware of those protections, it's in your interest to tell them about it, right? And that includes your right to get your claim file documents, the 36 months to collect your replacement value, and your right to replace your home by buying elsewhere, all right? Hot spots, common problems on partial and total, the extent of damage from heat and smoke, is the indoor air quality healthy and safe? What about your soft goods, your pillows, your furniture that can absorb the smoke and the ash? Whether something can be cleaned or replaced, preferred vendors that overcharge or underperform on total loss claims. If you're underinsured, who's to blame for that? And how much detail are they going to make you go into about all your contents? Are they going to give you a lump sum, or are they going to put you through your paces, having to do the traditional itemized list? And then, as we talked about earlier, how much would it cost to put that house back? Even though you probably don't want to put the identical house back, you still have to reach an agreement on that with your insurer. And then the issue of what benefits are available to buy a replacement home. Okay, briefly on underinsurance, so common, as I said, 2/3 of wildfire survivors find themselves underinsured. What are the effects of it? It compounds your stress, causes delays while you figure out what you're going to do, and it slows down individual and community recovery. The law is not what it should be. The law does not reflect reality. The law is that the insurance company has a general duty to procure insurance for your home as you ask them to, but they don't have a specific special duty to procure adequate insurance for your home unless they undertook that duty. And what that means in plain non-lawyerese is if you can show that you had a conversation with an agent or with the insurance company or any kind of communication and you have proof and you can show that you said, I'm worried that don't have enough insurance, or I want to go through the fast, fair, friendly review and tell me if I've got enough. And they said, you're fine. If that's you and you've got that evidence and you're not fine, you might have a remedy. You should have a remedy for underinsurance. But if all you have is, I'm sure that I asked for it, but you have no proof, those are very difficult cases to win. That said, United Policyholders has been on this case for many years. There are a number of lawyers in our Find Help directory that have taken underinsurance cases and settled them behind closed doors. But the law is still not great. So it's tough, but not impossible. So the bottom line with underinsurance, figure out how much your home should have been insured for, right? And then consult with a lawyer, a policyholder lawyer, read all the stuff on our website, and there's a lot of it. We have a whole underinsurance help section, and then you can explore your options. But as I said, the key moving forward, if you're underinsured, is to figure out how underinsured you are. And that can sometimes require you to pay somebody to do that replacement cost estimate, as I mentioned earlier. It's generally going to cost you somewhere in the $5,000 range. Ouch, I know. But if you are really underinsured, that's an expense that we think is worth incurring, because it's fundamental to understand how underinsured you are. This is a regulation that was our Department of Insurance's attempt to fix this problem, because we've been going to them for years and complaining, gosh, so many people find themselves underinsured. What are you guys going to do about it? Please help us. We've gone to court. And so the department wrote this regulation, and it says that when the insurance company insured your home, they were supposed to do all these things, right? They were supposed to do a very complete estimate. And so if you are underinsured, this regulation may help you establish that the insurance company did not do their job, and that therefore they should make you whole. Okay, we are really, I hope everybody is still with me. We haven't taken a break, and I apologize for that, but we're just going to keep blasting through. We just have a few more slides. Okay, so you have at least 2 years to file a lawsuit, so don't worry about that yet. The insurance company cannot retaliate against you for complaining to the Department of Insurance. You have a right to do that. And these are the things that they're not allowed to do, right? They're not allowed to threaten or intimidate you. They're not allowed to try to lowball you. They're not allowed to dig their heels in and leave you no choice but to hire a lawyer and file a lawsuit. It's not supposed to be that way. And they certainly are not allowed to try to discourage you from consulting with an attorney. Your options for getting legal help: you can hire a lawyer by the hour, which is okay for ghostwriting letters, or helping you if the insurance company wants to examine you under oath, which is a fancy way of saying interview you with lawyers. Let me just turn on the light here 1 second. It's getting dark, too dark to see. Okay, there we go. Okay. Okay, so hourly versus contingency fees. So hourly is, you need a lawyer for a couple hours. Contingency is you're going into court, and they're going to take a cut of whatever they get for you. It's the same as if you hire a public adjuster, you hire them on a contingency fee basis. So, it's we say very rare for a consumer to for it to really pencil out well for you to hire a lawyer by the hour to help you with an insurance claim. Some lawyers, if you feel like you need a lawyer to help you, you just can't deal, and that's okay. But hourly is going to add up way too fast with an insurance situation. So if you decide that you want a lawyer to sort of stand in your shoes like a public adjuster would, negotiate them the lowest possible fee that you can. Because again, insurance companies are very good at taking up people's time and dragging things out when they want to. Okay, with non-renewal and cancellation, you've got strong legal rights to, if you're a disaster survivor, your insurer can't drop you they have to give you 2 renewals after your loss. If you live in a zip code next to an area where there's been a disaster, you get at least one renewal. The department just put out a bulletin today, and we help them with that. And that's a whole nother issue. But if you have that problem, come to our website and type in the word dropped. Just a couple more things before we wrap up. Remember that an insurance claim is a business negotiation, right? So the better you document your loss, the more reasonable you appear, the better you're going to get, the better settlement you're going to get. That paper trail is critical. Adjusters have varying levels of dollar authority, right? And every one of them has a chain of command. So typical adjuster that you're dealing with doesn't have a lot of authority, meaning they cannot pay you more than, say, $5,000 at any one time without going to their boss, right? So understand that they often don't have the authority that you need, and you have to go over their heads. So we recommend being an effective communicator and doing that in writing. And we say, send one last letter summarizing what you want before you file a complaint with the Department of Insurance. Well, filing a complaint is free. And we're going to give you the phone number and the website for that. But, and that is a good way to get things resolved. But before you go that route, we always say, try to go up the chain of command. This is the typical chain of command at an insurance company. Sample letters at our website for doing all these things. And here's a little bit of wisdom from one of our volunteers who lost his home in a wildfire. The loss of your home, it's a deeply emotional loss, and emotion is the enemy of a good business deal. So when you're dealing with an insurer, a bank, contractor, the more you resist emotional decisions, the better it will turn out. And don't let businesses profit off your emotions. That's words of wisdom from Ken down in San Diego. Here are some of the publications that you can find on our website that were written by people like Ken. They're not professionals. They're just telling you what some of their tidbits of nuggets of wisdom from their experience. And you'll find those on our website. Here's the toll-free number for the Department of Insurance to file a complaint or ask a question. You can fill out a complaint form online. And I want to thank you all for your time. Now, I forgot to make a key announcement at the beginning of today's event. And that was that if you needed clarification on something that I said, or you had a question, that you could use the Q&A to get that clarification. But even though I didn't say that, we got a number of those questions. Because we've been going now for over an hour, hour and 20 minutes, I'm going to say that we're going to end the recording. And for those of you who want to stay on, we can go through the questions that are in the Q&A up until 5:30. And for whatever we don't get to, we will be doing a Q&A webinar. I'm hoping that I want to thank all of our funders that are making it possible for me to bring you this information, there they are. And these are foundations, and people have donated to them, and then they in turn are supporting this program, the Roadmap to Recovery program. These are our upcoming events. We've got a Q&A next Wednesday. If your question doesn't get answered in the next 10 minutes, I encourage you to come on next Wednesday. On the 19th, we'll be doing contents. We'll do another Q&A December 2nd, and then we'll be doing another one for mobile homeowners also on December 2nd. Now, all of these events are virtual. They're all online. We're not doing anything in person right now due to public safety considerations. I really want to thank my staff, Carolyn Winter, Valerie Brown, Mark Dillman, and our translators today, Annabella, thank you so much. So we're going to stop the recording now. I'm just going to say good night. Good luck.